I'd like you all to take a huge, deep breath. Inhale. Exhale.
That's Ghislaine Maxwell, the British socialite accused of luring minors to be abused by the late pedophile Jeffrey Epstein. In November 2021, the alleged madam will stand trial in the U.S. for what prosecutors say was her key role in Epstein's sex trafficking operation from 1994 to 2004. She's being represented by a team of top-tier attorneys from across the country. But who would agree to take on such a controversial case? I'm Margaret Cho, and this is what we know so far about Ghislaine Maxwell's defense. On July 2nd, 2020, Maxwell was plucked from her hideaway in Bradford, New Hampshire, and booked on charges related to her alleged involvement in Jeffrey Epstein's sex trafficking ring. 4 days later, she arrived at the Metropolitan Detention Center in Brooklyn, where she's awaiting trial in a unit separate from other inmates. According to her lawyers, that hasn't stopped rat droppings and raw sewage from getting in. Despite her and her lawyers' best efforts, it doesn't look like Maxwell is going anywhere anytime soon. In June 2021, she was denied bail for the 5th time in less than a year. According to her lawyers, Maxwell offered to pay $28.5 million for her temporary freedom, but a judge said no. So what has Maxwell been accused of exactly? The 2020 indictment charged her with 6 counts. 1, conspiracy to transport minors with intent to engage in criminal sexual activity. 2, conspiracy to entice minors to travel to engage in illegal sex acts. 3, enticement of a minor to travel to engage in illegal sex acts. 4, transportation of a minor with intent to engage in criminal sexual activity. And 2 counts of perjury. When people conspire to do something illegal, it doesn't matter whether they actually succeed in breaking the law. What matters is that they made an agreement to do so, and a step was taken by any conspirator to move the plan forward. NowThis spoke to legal expert and Lewis and Clark law professor Tung Yin, who told us.
In this case, those particular conspiracy crimes charge Ms. Maxwell with conspiring with the late Jeffrey Epstein to engage in various federal sex crimes. So as long as the government can prove that Ms. Maxwell and Mr. Epstein both agreed that they were going to engage in the particular actions, it doesn't matter if they succeeded.
2 of Maxwell's charges relate to her alleged role in luring and transporting minors across state lines in order for them to be subjected to sexual abuse.
And here, the nature of the crimes requires the government prove that the victims were underage and that they crossed the state lines and that they did so because of some enticement or inducement by Ms. Maxwell or Mr. Epstein.
The last 2 counts are perjury, the legal term for lying under oath. Someone commits perjury if they make a sworn statement or sign a document that they know contains false information.
There were some civil lawsuits in which Ms. Maxwell was deposed, meaning she had to give testimony under oath, and the government alleges that she made false statements during those depositions.
For example, Maxwell previously testified that she was not aware of the presence or use of sex toys at Epstein's residences, and that she did not give an underage girl a massage. The government alleges that isn't true. The evidence against Maxwell includes testimony from at least 3 unnamed witnesses who claim to be victims of Maxwell and Epstein between 1994 and 1997. All 3 witnesses were under the age of 18 at the time of the alleged crimes. Minor victim 1 claims she was abused by Maxwell and Epstein in New York and Florida, minor victim 2 in New Mexico, and minor victim 3 in London, England. Then in March 2021, prosecutors filed a superseding indictment in order to add more charges to the original indictment. According to prosecutors, they obtained new evidence after Maxwell was arrested that warranted escalating her charges along with the initial 6 counts. Maxwell is now facing 1 count of sex trafficking conspiracy and 1 count of sex trafficking of a minor. The March filing references a new witness, minor victim 4, who was allegedly trafficked by Epstein and Maxwell between 2001 and 2004. The indictment claims Epstein and Maxwell knew minor victim 4 was underage at the time and alleges Maxwell brought her to Epstein's residences to give naked massages and perform other sex acts on him. It also claims the underage girl was paid hundreds of dollars by him or Maxwell for each encounter, and that she was encouraged to find other girls to be trafficked, which she did. Maxwell has pleaded not guilty on all counts, but a not guilty verdict is, statistically speaking, unlikely. Only 2% of federal criminal cases actually go to trial, and in those rare cases, 4 out of 5 defendants are found guilty. Most cases don't go to trial at all because so many defendants take plea deals.
You know, the default assumption is that this is the nature of our current criminal justice system, that 9 out of 10 defendants will actually be convicted not because the jury convicted them, but because they convicted themselves.
Yin says in Maxwell's case, a deal is still possible.
So the question is, does she have anything to offer that is valuable enough to the government, and will the government offer enough of whatever sentencing reductions or charge reductions that would motivate her?
So far, she's maintained her innocence. The trial's still on, and her legal team is busy preparing her defense. But who are Maxwell's lawyers, and what kind of strategies could they use to defend her? As far as legal teams go, Maxwell's 5 are first class. They're all nationally recognized trial attorneys with expertise in criminal defense. Laura Menninger and Jeffrey Paliuka are shareholders in the Haddon, Morgan, and Foreman law firm in Denver, Colorado. They also represented Maxwell in a past civil case. Menninger, a former Goldman Sachs analyst, served as a deputy state public defender before joining Haddon Morgan in 2012. According to the firm's website, she's considered one of the top criminal defense attorneys in the country and focuses her practice on any case destined for trial, according to the Colorado Bar Association. She has co-authored Professional Defense of the Accused with Paliuka since 2009. According to his firm profile, Paliuka has been a trial attorney for 39 years, and he's been listed by Best Lawyers in America every year since 2005 in the areas of white-collar and non-white-collar criminal defense. More recent additions to Maxwell's roster include Mark Cohen and Christian Everdell, who are partners in the New York City office of Cohen and Gresser. Cohen co-founded the firm in 2002 and heads its white-collar defense and regulation group. But his experience isn't limited to defense. In 1992, Cohen helped to convict mafia hitman and martial artist Tommy Karate of murdering 6 people. After nearly a decade as the assistant U.S. attorney for the Southern District of New York, Chris Everdell joined Cohen's firm and his white-collar defense group in 2017. While working for the government, Everdell specialized in terrorism and international narcotics. Like Cohen, he's no stranger to high-profile cases. Everdell helped take down Sinaloa's drug cartel kingpin Joaquin El Chapo Guzman. Cohen and Everdell's experience prosecuting federal criminal cases could certainly give them an advantage in strategizing for Maxwell's trial. Last but not least is Bobby Sternheim. According to court filings, Sternheim runs her own practice in New York City, though she is listed online as counsel for the law firm of Fasulo, Braverman, and DiMaggio. According to her firm profile, Sternheim has top security clearance and often handles cases related to organized crime and international terrorism. Notably, she defended Khalid al-Fawaz, Osama bin Laden's London-based spokesperson, for his role in the 1998 bombings of 2 U.S. embassies in East Africa that killed 224 people. Sternheim is a former president of the New York Women's Bar Association, and its website describes her as the first and so far only woman to receive the New York Criminal Bar Association's Award for Excellence in the Profession. She's long been an advocate for women in the courtroom, noting in a 1992 article for the New York Law Journal that women remain the predominant victims of violence in our society. Although violence towards women, particularly rape and sexual abuse of women and girls, is given increasingly high profile in the media, the plight of battered women has just recently become recognized. Sternheim wrote that while the law has traditionally been a conservative force which has perpetrated the subordinate status of women, it's also the most important tool available to the American people to shape social injustice. Sternheim's history of supporting survivors of abuse and gender discrimination may seem at odds with the job she's taken, but the way Tang Yin sees it, defending those accused of the most heinous crimes is, in a way, a progressive cause.
Having somebody who will represent even the seemingly worst defendants, who will represent them vigorously and zealously, provides society with what I think is a measure of confidence that when people are convicted and sentenced to long terms, that it was not a show trial, that there was a real defense in place, that they had somebody who stood up and forced the government to the burden of its proof. We know there are mistakes that are made, there are wrongful convictions, but at least we can sort of minimize those if we actually have defense lawyers who really are giving it their all, no matter how horrible we think that their clients have been.
That's one way to look at it. But there's a more pragmatic way to interpret a lawyer's decision to take a case like Maxwell's.
Now you can imagine for that particular lawyer or those lawyers, what a great calling card that is for future clients. Look, this case that nobody thought we could win, we won. We got our clients acquitted. That's going to, drive in a lot of future business.
Still others have speculated that Maxwell's attorneys may encourage her to plead out. Soon after Everdell joined the team, Jennifer Rogers, a CNN legal analyst who specializes in anti-corruption, tweeted, "Chris Everdell was a longtime SDNY AUSA, who I happened to supervise once upon a time. He will, of course, do what is in the best interests of his client, but no doubt he will be talking to her about the benefits of becoming a cooperating witness." That's not to say Maxwell's attorneys are in any way trial shy. Medinger, for example, is an expert in cross-examination. In an interview with women criminal defense attorneys, Medinger said she subscribes to the chapter approach, an organized method of cross-examination designed to keep the jury engaged and give witnesses less time to establish their credibility. Basically, each point the attorney wants to make becomes its own chapter of questions that start broad and get more specific. Whether the goal is to expose bias, make the witness appear less credible, or something else, the chapters are told in the most persuasive order. Eventually, if it's successful, the witness logically arrives at the attorney's theory.
You, however, had time to hide the gun, didn't you, Chutney? After you shot your father.
I didn't mean to shoot him. I thought it was you walking through the door.
Remember, with a jury trial, a little doubt can go a long way. A favorable outcome for Maxwell could be as simple as convincing one juror that she may be unfairly taking the fall for Epstein's crimes.
If they can persuade one juror that there is reasonable doubt about whether Ms. Maxwell knew what Mr. Epstein was doing and whether she helped him, that is enough to get a hung jury. It's not exactly a legal argument, but if they can build some sympathy for her in the eyes of the jury and make it seem like she's a scapegoat, that might be one of the things that might tip one or two or how many jurors over into thinking that there is reasonable doubt.
Jury selection for Maxwell's trial is expected to take place in mid-November, and opening remarks will happen November 29th. At issue will be her role in the alleged sex trafficking operation, but not her alleged perjury. That's because on April 16, 2021, Judge Allison Nathan decided Maxwell will face the sex trafficking charges separately from the perjury charges. In her decision, Nathan noticed that tying them together would risk an unfair trial, since Maxwell is accused of lying in a civil case where she was represented by Medinger and Paliuca, meaning they could potentially be called as witnesses or be disqualified. Former federal prosecutor David S. Weinstein told the Tampa Bay Times that the separation of the charges into two trials does little damage to the prosecution's case, and he suspects Maxwell will only face the perjury charges if she's acquitted in the first trial. For that, we'll have to stay tuned. If convicted on all counts, Maxwell could face up to 80 years in prison. The sex trafficking charges alone carry a maximum prison sentence of 40 years, which at 59 is effectively a life sentence. For more on Ghislaine Maxwell, be sure to check out the brand new docuseries Chasing Ghislaine, now on Discovery+.